The state of Wisconsin has joined yet another lawsuit opposing the Affordable Care Act. Our Attorney General Brad Schimel has joined about 20 other states in opposing the Affordable Care Act. They argue that the Republican budget bill eliminated the individual mandate shared responsibility payment, or the tax for not having insurance, and therefore the whole Affordable Care Act is unconstitutional. That's the argument. We know this is not the first attempt to undermine the Affordable Care Act, not only in the legislature, but also in the courts, and the state of Wisconsin has joined many of those lawsuits opposing the Affordable Care Act. Let's first remind ourselves of what the individual mandate is and what that penalty is that they're referencing, and then we'll look at the merits of the case. The individual mandate is strictly the provision of the Affordable Care Act that requires everybody to have health insurance or pay a penalty. The idea is this brings more people into the insurance pool. This only works if everybody's in it. If you choose not to be in the pool, then you're going to have to pay a penalty, unless you have other qualifying coverage, such as Medicare or Medicaid or employer-sponsored insurance. Otherwise, you should have insurance through the marketplace or through an insurance company. And the idea is that this stabilizes the pool. If we have more people required to have insurance, that means we have more healthy people required to have insurance. That offsets the cost of the sicker or lower income individuals that need care. That's the individual mandate. The penalty is, again, that penalty for not having insurance. If you go longer than 3 months without having insurance, longer than the duration of a grace period, then you will pay a penalty on your taxes for not having insurance. Now, the GOP tax bill that's referenced, the Tax Cuts and Jobs Act of 2017, as it's called, was passed in December, signed by the president, and it ends the tax penalty for not buying health insurance starting for plan year 2019, and you would see that penalty disappear in your 2020 taxes. But it did leave the rest of the Affordable Care Act in place, including the rest of the individual mandate. Now, that nuance matters because the entire individual mandate was not struck down. Some folks are referring to this as the individual mandate repeal, when it actually is just zeroing out the penalty. That nuance matters because things like essential health benefits and the rules of having qualifying health insurance and even tax credits for small businesses all hinge on the language that appears in the individual mandate. So even though it seems like a nuance, it is an important distinction to say it's just the tax penalty that gets zeroed out. The whole individual mandate is not gone. And that actually could be what is the linchpin of the success of this lawsuit that we're referencing here. The legal challenge says that the Supreme Court previously upheld the individual mandate solely based on Congress's power to tax. Therefore, if you get rid of that tax penalty, then the whole law is unconstitutional. You can't sever out that tax ability to tax provision from the rest of the Affordable Care Act. If that's gone, then the whole thing is gone. Now, that's a very direct reading of the tax penalty part and the individual mandate. Now, the suit has, as you can imagine, drawn substantial criticism from both political sciences, from healthcare advocates, from healthcare policy experts, and from consumers. It's been criticized as weak, as a nuisance lawsuit based on politics, not law, and one that lacks standing. In order to even bring a lawsuit, you have to show harm. And there has yet been no harm shown. In fact, people not paying a penalty would actually be less burdensome than the way that the original law was written. Now, potentially, this gives states another reason to act to thwart the law. If anything, this was seen as a little bit of a nuisance and something just to throw up in the face of CMS and say, you know, we're just not going to follow this anyway. You can read the lawsuit yourself and see what you think. That distinction between the individual mandate and the individual mandate penalty might be the linchpin in this. Most states that are not joining the lawsuit are doing so, saying it's something that shouldn't even be making it into the courts in the first place. You can read the suit, see what you think. You can also read a couple articles of interest and see a little bit extra perspective on this topic. You can also weigh in and share your ideas with us directly, and you can do that at healthwatchwisconsin.org. Thanks for joining us.